Good afternoon, honourable colleagues. I don't know about you, but I'm very much getting the vibe of a classroom at the last day of a school term. A lot of restlessness in the room, and very conscious of the fact that I'm standing in the way of the end of that school term. I want to thank all senators who've spoken on this bill, and for those who have moved amendments, I want to thank especially the sponsor of the bill for his diligence in advancing this important piece of legislation. I've already indicated to all of you in an email that I intend to move 2 amendments, and I've telegraphed my intention early on in the debate, starting at Committee of the Whole, when I asked questions to the Minister on the very topic, one of the very topics of the amendments I will be moving. Let me say at the outset that I'm a supporter of Bill C-5 for all of the reasons articulated by other supporters of the bill. And for that reason, my amendments are, I believe, consistent with the bill, and not only consistent, but they address what appear to be either oversights or discrepancies, intended or unintended, which I believe even the government accepts to be the case. Since signaling my intention, I have been very fortunate to have had conversations with government representatives who have presented to me various assurances of how they recognize the flaws that I've pointed out in the bill and would seek to remedy those errors. I won't report more fully on those essentially private conversations, but there's an opportunity, of course, for the government to say more about that at the end of my speech. Colleagues, the 2 items that I will be raising shortly have to do, first of all, with a discrepancy in the bill that came out of an amendment from the House of Commons. You will know that the bill sets out a number of factors for the determination of projects of national interest, and that there are 5 criteria for this determination. At the same time, there is a new provision in the bill, again moved in the House of Commons and adopted by the House of Commons, which sets up a register through which there will be reporting out on the ways in which projects deemed to be of national importance have met the criteria in the selection of the projects in the first place. Curiously, the criteria list in the register does not correspond to the list in the factors section of the bill. And the item that is missing is item E, which is, I quote, contributing to clean growth and meeting Canada's climate change objectives. Now, this is a very curious thing indeed, that we would, on the one hand, set up a criterion for designating a project and not have the requirement to report on it after having selected the project. The government has assured us, and this is on the record from Senator Youssef, that this is not the government's intention. I believe that to be true, and I also believe to be true that if this amendment doesn't happen in this chamber, they will do what they can to remedy the situation. But it does beg the question as how this discrepancy came about. And the story, it seems, is that it was an amendment moved in committee by a Conservative member of Parliament. And I don't know, maybe it slipped through, maybe people weren't paying attention, but it got through. It got through. And, well, we can assume less charitable interpretations, but one interpretation for sure is that there is an intention for this criteria to be given less weight. And I don't think that would be right. insofar as what we would want to see, I think, in the classification and designation of national projects. Now, I again do not doubt the government's good intentions to fix this problem as soon as they can, and they may well have to do it in the absence of an amendment here. But we are in a minority government situation, and there may be partisans in the other house that are determined and may well be explicit in wanting to exclude item E from consideration in the register. That's the first amendment that I will be moving shortly. The second amendment is a little more esoteric, but maybe I've brought it up enough times in this chamber that you get the gist of it. It has to do with the Statutory Instruments Act, which has been essentially nullified by this bill. The SIA is an arcane piece of legislation that, in truth, does set up procedures and reporting requirements and various consultation processes that can be seen to be cumbersome and which may rightly be described as unnecessary red tape. I understand it's the government's intent to do away with some of this cumbersomeness and red tape in order to not only speed up the process of project approvals, but more importantly, to provide greater certainty to project proponents that projects of national interest will not get bogged down. I think that's a good objective. And what I'm about to propose does nothing to get in the way of that. But the SIA, sprawling as it is, also includes a provision that gives the authority to the Joint Standing Committee on the Scrutiny of Regulations, which I've had the privilege of sitting on and chairing in previous parliaments. And this committee looks at regulations, statutory instruments, pursuant to bills that we pass, to make sure that those regulations are consistent with the bills that were passed. It's obvious that we cannot go into the minutiae of the regulations that are needed for any bill that needs to take effect, and that's why we have in this Parliament and in all Westminster parliaments this kind of committee to look at the consistency of regulations with the law. Unfortunately, by eliminating the application of the SIA holus bolus, Section 19 of that Act also takes effect, which nullifies the work of the Scrutiny of Regulations Committee. Now, the government will correctly say that there's an alternate mechanism that has been set up through amendments made in the House of Commons. It's the Parliamentary Review Committee, and it's based on the powers from the Emergency Measures Act. I understand it's also to be a joint committee, and it will have the ability to look at the way in which this bill is implemented. That is a good step, but it does not amount to a Scrutiny of Regulations Committee for essentially two reasons. The first is that the Parliamentary Review Committee will take more of a broad brush approach to whether the minister has been exercising her powers or his powers correctly, and whether the broad sweep of the way in which C-5 is being implemented is kosher, if I can put it that way. It will not, I do not think, go into the technical details and have the technical expertise to help that committee point out what may be fine legal errors in the regulations in relation to the bill itself. And that kind of specialized work with specialized support from a dedicated technical secretariat, a legal team, in other words, is available to the Scrutiny of Regulations Committee. Furthermore, the parliamentary review mechanism that has been set up does not have the power of what's called disallowance. disallowance is where a committee, the Scrutiny of Regulations Committee, can, after a rigorous process of investigation and questioning of officials and maybe even the minister, can disallow a regulation because it does not conform to the law. Now, this power is used very, very rarely. It's only taken with the full agreement of the committee, a committee that is characteristically non-partisan. And in the last parliament, we had the, I guess, unfortunate experience of having to give an intention to disallow regulations in 5 areas, which I won't go into. But I will say that the act of giving a notice of intention to disallow regulations in 5 different bills led to corrective action on the part of the departments. In some cases, in other cases, the process is still ongoing. My point simply is that this power is real and it can have positive effects in bringing regulations in conformity with the law, and that it's used with great reservation. And so you don't expect that this committee would take any other approach in the review of C-5. Now, there may be a way in which the Parliamentary Review Committee can incorporate scrutiny of regulations into its work. If this amendment doesn't pass, perhaps that's something that we can collectively look at or the government can propose. Colleagues, I will shortly read the text of the amendment. Let me say that I hope it passes, but I'm not going to press for a standing vote. And if it fails, I will still go on the assumption, or I will go on the assumption that it failed because, we're going to trust the government to fix the problem themselves. And that it will happen one way or the other. And with that, colleagues, I move that Bill C-5 be not now read a third time, but that it be amended in Clause 4, A on page 11 by adding the following after line 25, 8.1, despite subsection 8, section 19 of the Statutory Instruments Act applies to an order made under subsection 1, 3, or 4 as if it were a statutory instrument. 8.2, despite subsection 8, section 19.1 of the Statutory Instrument Act applies to an order made under subsection 1, 3, or 4 as if it were a regulation. B on page 12 by replacing line 6 with the following. The outcomes set out in paragraphs 5, bracket 6, brackets A to E. C on page 14 by adding the following after line 7. 7.1, despite subsection 7, section 19 of the Statutory Instruments Act applies to the document as if it were a statutory instrument. 7.2, despite subsection 7, section 19 of the Statutory Instruments Act applies to the document as if it were a regulation.